Hello and welcome to You and the Law. I'm Mike Monta, your producer and host for tonight's program. And this is the first show of our current season starting in 2014. And the topic for tonight's program, a very interesting one. I think we're going to be talking about the courts here in Montgomery County and a judicial perspective of that. Special guests joining us on the show tonight will be Mary Wiseman, who is judge currently on the Common Pleas Court, and Jeffrey Froelich, who is judge of the 2nd District Court of Appeals, not the only judge, but a judge there. And we will discuss the roles of the courts and how the courts function and how they affect you, the viewers, out there in our viewing area. Before we get to our panel discussion, let me remind you that You and the Law is a monthly presentation produced here at the studios of Dayton Access Television. DATV is on Channel 5 here in Dayton. It's the public access channel of Time Warner Cable Network in Dayton. Now this year, for the first time, we're broadcasting live to areas outside of Dayton, and I think that would include Englewood, Clayton, Trotwood, possibly the eastern areas of our county, as well as part of Clark County. If there's more, I'm sure somebody will let me know. It's Channel 6, I think, north and south of town, and wherever else Time Warner brings you the government channel. Program's also cable cast on tape delay, which is probably digital delay now, and that is shown north and south of town through the auspices of the Miami Valley Cable Council. We also stream live at DATV.org, so if you are watching us on that, you can still catch us live and call in. This is an audience participation program. We have a number which is right there, 223-5311. So if you do have a question about tonight's topic or something you'd like to ask the judges, please call in and we'll put you through as soon as we possibly can. So we're sponsored by the Dayton Bar Association, which has been in operation since 1883, which is longer than me or the judges coming to you tonight, probably combined, serving the citizens of the county. So let's turn to our guests, and we'll have them introduce themselves a little more fully, tell you, the viewing audience, about their background and familiarity with today's topic. And Judge Froelich, welcome to you. Many-time visitor over the years.
Frequent flyer.
A frequent flyer. You're on.
Well, for what?
Well, tell us about yourself, your background, how you got to be a Court of Appeals judge, what happened to you along the way, things like that.
Yeah, I was born in Dayton, went to Fairview High School, went to Miami University, stayed out of school for a year to join the Army Reserves, and went to the University of Michigan Law School. Came back here and worked for Lee Falke in the County Prosecutor's Office. Was a full-time professor at the University of Dayton Law School. In '78, I was elected to what was then known as the County Court, is now the Municipal Court of Montgomery County. Served on that court for 16 years, and in '94 elected to the General Division of the Common Pleas Court. In 2008 to the Court of Appeals, and then I'm on the ballot again this fall.
Thank you. And thank you for being
life in a nutshell.
Thank you for being with us. And now we turn to Judge Mary Wiseman. Good evening, Judge. Tell us a little bit about your background, bringing you to the Court of Appeals. Or the Common Pleas Court.
Yeah. So I've not been either promoted or demoted to the Court of Appeals. So depending on your perspective. So I joined the Montgomery County Common Pleas Court General Division bench in 2007, having been appointed by then Governor Ted Strickland, and have held that position since. And prior to that, I was an attorney in private practice in the city of Dayton, And my practice focused on practicing in courts nationwide at both the state and federal level. I had attended law school at the University of Arkansas in Little Rock, Arkansas. And I'm not a Dayton native. I grew up just outside of Indianapolis in a little town that most people have seen the sign for when they're driving on I-70 into Indianapolis. A little town called Greenfield, Indiana is where I'm from, Mike.
The heart of Indiana and the most beautiful spot there, right?
You know, the cornfields are always green in Greenfield.
Well, that's great. Often we hear people who may have some problems in their lives, criminal or civilly. Somebody says, well, tell it to the judge. Well, tonight we're going to get to have the judges tell it to you by explaining what the roles are, how you experience justice and how you dispense with it.
Dispense with it?
Or of it. Either way. We have a bet here that Judge Froelich would make me laugh tonight, but I'm trying to hold back. And I probably will once he starts into telling us about what the courts do or not.
Okay. What is
I've already lost.
just one $10?
Yeah, okay.
Yeah.
If gambling were legal, of course.
Yes. All right. Okay. Judge Froelich, what does a Court of Appeals judge do, and then how do cases get to this Second District Court of Appeals or a Court of Appeals, and are they criminal cases, civil cases, and do you do any trials?
Yes. No. The world's kind of divided into two kinds of courts. You've got the trial courts and you've got appellate courts. In trial courts, you have courts of general jurisdiction, courts of limited jurisdiction. Limited would be your municipal courts that would have limited amounts of civil dollars involved and limited criminal penalties, usually misdemeanors. The general jurisdiction, such as where Judge Wiseman sits, has general jurisdiction. It may be broken up into probate and domestic relations and juvenile, but otherwise it's any type of case you can imagine. Now, from those courts, if someone wants to take an appeal, they go to the other side, and that's the appellate courts. Appellate courts are not county by county, but rather district-wide. So there's 12 districts in the state of Ohio. And the Second District Court of Appeals includes Darke, Miami, Champaign, Clark, Greene, and Montgomery counties. So any appeals from any of those courts, limited, general, divorce, juvenile, probate, criminal, civil, if you have an expired tag on your plates on your car, anything, multi-billion-dollar malpractice cases, aggravated murder cases, A to Z, accidents to zoning, anything you can think of would be appealed, and you have an automatic right of appeal to the Court of Appeals.
And the person coming to the Court of Appeals is the loser of the case below, right?
The person, sometimes both sides can appeal. In a criminal case, it's going to be one side or the other, but in a civil case, if there were multiple causes of action that they were suing each other for, sometimes both sides could be appellants, that's the person that's appealing, and an appellee, that's the person against whom the appeal is being made.
Okay. So let's talk about the Common Pleas Court. And Judge Wiseman, you've been on the bench, I'm sure you said this before, but the last several years. Mm-hmm. And what kind of cases appear there, and what is the role of the judge in those cases?
Well, the Common Pleas Court in Montgomery County, we have a general division, and we have a juvenile court division, a probate division, and a domestic relations division.
And you're on the general.
And I'm on the general. Okay. And so there, as Judge Froelich said, we handle from A to Z. We handle on the criminal side predominantly felony level criminal proceedings, although occasionally we'll handle a misdemeanor level criminal case. But for the most part, Mike, the misdemeanor cases go to the municipal courts, and the felony level criminal offenses that come to the common pleas court. And on the civil side, it really is A to Z, soup to nuts, everything from regulatory issues to personal injury accident cases, medical malpractice cases, contract disputes, home foreclosures, credit card collection cases, just any type of dispute that you can imagine really that might arise between two people or a business and a person or vice versa. Those are the disputes that come to the trial court. And the role of the trial court is to provide a process for those disputes to be resolved. And often that is through having the dispute go to trial. And a dispute at trial can be resolved through either a bench trial or through a jury trial. And I think most people think of jury trials as that dispute resolution mechanism. And then the trial court helps guide the case through the rules and the process and procedures that have to be used so that the process is fair and square for everybody that's involved in the system. And then the work that the trial court does gets reviewed by the Court of Appeals. So, as I like to say, that the Court of Appeals checks my math, so to speak, as they would, if folks had taken a class in school and the teacher goes and checks the math or reads the essay that you've written and grades it. So we're trying to do our work in a way that conforms with the law and conforms with the rules that apply to our work. And the Court of Appeals reviews that work and makes sure that the trial court has done its work appropriately.
The criminal cases, of course, originate with police agencies or the prosecutor's office, whereas civil cases are dependent on somebody actually filing something in court.
Correct.
How are those divided up as far as time is concerned? The criminal cases, of course, have a speedy trial time, and the civil cases, it seems like they could take forever. So what is the role of the court in administering justice in both types of things? It's like juggling, I guess, when you're sitting there.
It is. In Montgomery County, we're a urban court with a high volume of cases. So I have 10 colleagues, so we have 11 general division judges on the Common Pleas Court. And roughly speaking, each of us carries somewhere between 200 and 300 civil cases at any one time. And we carry anywhere from 50 to 90 criminal cases at any particular point in time. And then in addition to that, we're also responsible for individuals that in criminal cases we've put on probation. And we're also responsible for example, hearing the petitions that might be filed by folks that we've sentenced to a term of imprisonment. So we have a lot of work that gets done, and our time really gets spread across all of those areas. Now the criminal cases are a little different because the Constitution requires that so much that occurs in a criminal case, the judge and the defendant, as well as the defendant's attorney and the prosecutor, are all together in handling components of that particular case. So those cases tend to take up a lot of the court's in-court time, that 9 to 5 type of time. Civil cases tend to be very paper intensive, and so there's a lot of work that goes on behind the scenes to read briefs and read motions and write decisions and orders and entries to resolve those motions that are filed in civil cases. So they both require time. Sometimes just a different sort of skill set gets brought to bear depending on the type of case that it is.
What are the types of cases then that you would review or try or whatever that are going to wind up in the Court of Appeals?
Anything and everything.
I mean,
anything that's a final appealable order.
Okay.
So I have to the trial court has to have concluded the case or have designated that although that's not concluding the case in its entirety, there's a good reason for why the Court of Appeals ought to look at something piecemeal. And the Court of Appeals doesn't always agree with the trial court.
We'll find out about that in a minute,
when we
yeah.
say this is an important issue, and even though it's not concluding the entire case, we think that the Court of Appeals ought to take a look at it because it's going to play such an important role in what's left of the case. But for the most part, there are a very small handful of cases that bypass the Court of Appeals and go directly to the Ohio Supreme Court, and with the most notable example being death penalty cases. So in the event of that, we would conduct a trial on a capital case and a death penalty were imposed, that because of the overall importance of that issue in the law and in our society, the law has that case go directly to the Ohio Supreme Court for review, whereas normally they would have to, for other cases, go through the Court of Appeals and then try to go into the Ohio Supreme Court, which may or may not take the case.
Cases that are resolved don't go to appeal, correct?
Yes.
Both criminal and civil. So does the judge's role at the common pleas level entail encouraging resolution, do you think?
And the answer to that is yes, because about 98% of our civil cases end up settling. So they don't reach that step of needing a jury trial or a bench trial. And so the court tries to facilitate those compromise resolutions of disputes, and we do that in a whole host of ways. We have mediators that we bring in to work on a case to see if they can resolve the dispute. In appropriate circumstances, even the judge can get involved in trying to see whether or not the parties, when they're really focused on their own best interests and are understanding the risks and rewards associated with going to a trial, try to find a way that they can compromise their dispute and get that dispute put to rest without having to take that step of having a trial. So the court's very involved in that because it's cost effective for the people that are involved. It generally costs less in attorney's fees to have a case settle. They get finality, and they also then eliminate the risk of having a verdict reversed by the Court of Appeals.
All right, so Judge Froelich, you don't get any of the resolved cases, I guess.
We don't get them first time around. Sometimes what will happen in a civil case is the parties will enter into an agreement. Then a year down the road, something goes wrong, and there'll be a motion to enforce that settlement or the agreement, and the parties will start arguing over what that settlement agreement was. That'll be initially before the common pleas court, like Judge Wiseman, and then that may end up in the Court of Appeals. Same way with a criminal case. There may be a motion to withdraw the plea afterwards, and the judge again would rule on that at the trial level, and that could be appealed. But obviously that most you're appealing because you think something is, the judge made some sort of error at the trial level, and if everybody's agreed, even if they're mutually dissatisfied with that agreement, they've entered into an agreement and they're getting on with their lives.
Is it the court's experience, the appeals court, that if there is a trial, civilly or criminally, that is going to get appealed and in front of the court? Or do some of them just not do anything?
No, the vast majority of cases don't get appealed. There's a lot more cases at the...
I mean, the ones that go to trial and somebody loses. A criminal defendant is convicted, or somebody isn't satisfied with a civil verdict.
Well, and those are going to get appealed. The number winnowed down between the trial courts And then the 1 in 25,000 cases filed in Ohio is ever going to end up in the Supreme Court, for example. So the cases are getting winnowed down as you go up. And it's important to remember that the Court of Appeals is not a second bite at the apple. It's not best 2 out of 3. Okay, the jury came back this way, criminally or civilly, and I think I want to have somebody else take a look at it. We don't have juries.
Mm-hmm.
The only rule there's no exception to in the law is that there's an exception to every rule. So we don't have a court reporter 99.9% of the time. What we are doing is reviewing whether with the information that was before the trial court committed an error that requires some action on our part. It wasn't harmless error. It wasn't, well, somebody asked if somebody had brown shoes on and that had nothing to do with the case. The judge shouldn't have let that in, but it didn't have anything to do with the outcome of the case. So even if that was a mistake, the judge cited the wrong rule of evidence and let it in, that's not going to be reversed. It has to be a legal error that made a difference in the outcome of the trial.
Or could have made a difference in the outcome of the trial.
When the cases are appealed, do you find there's more criminal cases that are necessarily coming up because there's probably more criminal trials? Or are there a fair amount of civil appeals too?
There's a fair amount of civil appeals, but about 65% of our appeals from the 6 counties are criminal. And then you get civil and domestic, as Judge Wiseman said, automobile accidents, contract disputes, things like that. You get administrative appeals, you get domestic relations appeals, some things from juvenile court, some things from probate court, some original actions, but the majority of cases are criminal cases.
Well, one thing that Judge Wiseman said, and the law changed in this a number of years ago in the death penalty cases, is that Second District Court of Appeals is not, or every District Court of Appeals is bypassed on the appeals of death penalty cases.
Direct appeals.
They're direct to the Supreme Court. And
because the Court of Appeals can get some ancillary matters arising out of death penalty cases.
Mm-hmm.
Without getting too much into the weeds, if there's
Right.
motions to withdraw pleas or post-conviction relief and some other matters. But the appeal of the conviction itself goes directly to the Supreme Court.
Okay. We're about a half an hour into the show, and you are watching You and the Law here on Channel 5 or perhaps Channel 6 somewhere else, and we're talking about the courts, and we've been talking about the Common Pleas Courts and the Court of Appeals and the judicial perspective of those, and we have 2 judges, one from the Court of Appeals, Judge Froelich, and Judge Wiseman from the Common Pleas Court. And we are, as I said, coming to you live and in color, and please call in at the number, which, am I seeing it there? 223-5311. And we don't have any commercials, so I'm going to be the commercial here just for a second. This case is, see, we're back in the court, and this show is sponsored by the Dayton Bar Association, serving our community since 1883, as I mentioned before. Bill Wheeler is the executive director of that organization. And he asked me to talk about some of the things that the Bar Association does for its members and the county. One is a lawyer referral service where, if it's a nonprofit service of the Bar Association, and if you don't have an attorney, don't know where to look for one, don't have any friends that want to recommend anybody, you can call 222-6102 and you'll be matched up with an attorney who specializes in the area that you want to address. We also have some.
There's a very minimal fee for the first.
The fee is actually $35. Thank you. It was $10 when I first started practicing, so you can see
We
how
only had 30 stars on the flag back then also.
that's true. At any rate, call now and it's only $35. They've also instituted a thing called Dayton Find a Lawyer, and this is at www.daytonfindalawyer.org, and it's an online search site, and potential clients can see actual personal profiles. That's true, isn't it? And I don't know how many are availing themselves of it. It's a new thing and a new program, and might be helpful. The website is www.daybar.org. Notary public service we have, and also Wills for Heroes program, where members volunteer to create wills and estate documents at no charge for emergency first responders, fire, police, and EMT. And lastly, on Bill's sheet anyway, I think they have a lot more than this. There's a speakers bureau, and if you want a speaker, an attorney, a judge, perhaps one of these judges, I don't know, to speak at Service Club or other community events on a variety of legal topics, call the Bar Association's number, which is 222-7902. And Bill, if you're listening, I want you to call into the show here tonight. So, okay. So back to the show. Again, we're talking about a judicial perspective of the courts, which, and I know judges aren't supposed to comment on this, but but, and you can tell me that you're not going to, I suppose, but which sorts of cases do you find create the most interest intellectually to you, if any?
Well, I think they're all interesting. And the important thing to know, Mike, is that as judges, we recognize that every case is important to the people that are involved in it. And if that doesn't make it interesting, nothing else really matters, to be honest with you. They're interesting because they're important. And they're important to the people that are involved in it. And the courts never forget that these are serious issues, that people's lives often hang in the balance. Their finances hang in the balance. Their homes hang in the balance. Their relationships with other people hang in the balance for how these cases are resolved. So I can't really say, well, I like this type of case, or this other particular type of case has more human drama, so we're drawn to those types of cases. We try to create a situation where we find all of the cases interesting to us, because they're all important to real people. The people that are out here watching the show often have cases that come into our court. And those folks need to understand that the issues that they bring to us, the claims and the defenses, the criminal allegations against them, those are all important to us. And we try to give each person in each case the dignity and the respect and the time that it deserves, so that those cases can be handled appropriately under the law. And when people leave the courtroom or they leave the court system, they will know that they've had their fair day in court, that they've been treated well, and that justice has been done on their case. Now, that doesn't mean they're always going to agree with the outcome.
Half of them won't, right?
Right. I work in a system where 50% of the folks that come in front of me end up getting a result they don't want, because it is often winner-take-all type, which is, again, why it's beneficial often to settle the case, because that sometimes ameliorates that zero-sum game or winner-take-all component of our adversarial legal system. But even though you might not want the result, the folks who are walking out of that courtroom door, who are walking out of the courthouse, need to know that myself and my colleagues, Judge Froelich and his colleagues, are doing everything in our power to make sure that the system is just and fair, that nobody has pre-decided their case. We're deciding the cases on the basis of each case's unique facts and circumstances and applying the law to everybody the same way.
Sometimes when I'm speaking to non-legal groups, trying to explain what a court does, I'll just ask them, what's important? What's important in your life? And somebody will say, my family, or my job, or my home, or my religion, or my children, or whatever it is. And then we'll break that down and say, okay, you're talking about your home. Is that a zoning concern? Do you want a muffler shop put in next to you? Is it eminent domain? Is the highway going to go through it? Is it going to be foreclosed on? Is it going to have to be, you're getting a new roof on it? Is it your family? What about custody? What about adoption? What about divorce and dissolution? Any employment, are you an employee? Or are you really an independent contractor? Were you injured during the course of your employment? So can you do workers' compensation? Is there a discrimination issue? Any of those issues, as Judge Wiseman said, are going to end up in court. And those are important issues for those people. So when I was in municipal court, and we did maybe 10,000 cases a year, and common pleas, then the case docket was a little higher with foreclosures and things that were going on earlier on in the late 90s, maybe 1,000 cases a year. You add all those up, and I've had several 100,000 cases, but I don't look at them as, just as Judge Wiseman said, they're not cases. They're people. They're problems. And so when someone asks me, what's your favorite case, I always tell them it's the next one. It's the case that involves that person, that company, that dispute between governments, whatever it is, that has a real import on their life. Just as a doctor, I would hope, doesn't say, I'm doing 3 heart stents today. I had 3 gallbladders. I have 3 lumpectomies. Well, that's not the case. They had 3 human beings that are on that table, and that case isn't, if it's that doctor's 1,000th procedure like that, or my 1,000th possession of drugs, it's the first one. And it's the one that matters, and that's what every judge that I've known in my years, and I'm sure that Judge Wiseman thinks the same way, that's the way we try to approach it.
Both of you have had experience also with the juries, and most of our cases that wind up in the Court of Appeals probably start or are resolved with a jury. And I think there's been talk since I began practicing a number of years ago, and you have too, about what do we need juries for.
Juries are democracy. Okay? 95% of all jury trials held in the world were held in the United States. And pundits or someone that says, look at this crazy verdict. They awarded billions of dollars, or they didn't award anything. How could that happen? Well, that's like saying, look at such and such a candidate that got elected. How could that happen? Because that's what the democracy voted for. And you can't throw out democratic elections by saying there was a crazy person elected in some other state, and that shows that the system doesn't work. Any more than you can say, oh, here's a jury. There's 100 million limited jurisdiction cases filed a year, about 10 million general jurisdiction. And you're going to find some frivolous lawsuits, some verdicts we don't understand. But those are the exception. And because you hear about them, that shows it's the exception proves the rule. But by and large, you can't throw the baby out with the bathwater. You can't say, well, here's a crazy decision. What do we need a jury for this? They don't really understand this. That's democracy. They're making the decisions.
Do you think that sometimes the things that are reported as crazy decisions, and I'm saying they're crazy because they're reported, and not to criticize our friends in the Fifth Estate, I think it's the Fifth Estate, there's usually a rational basis for what they term as a crazy decision, the McDonald's hot coffee case or something like that, which unless you are in the system, you can't believe that that would happen.
Well, Again, I think what Judge Froelich was saying is there are cases that appear to be anomalous, that the outcomes are unusual. And so those cases garner a lot of media attention, potentially because they seem to be unusual. But those are so incredibly rare. And again, those cases have the opportunity for appeal and review. So if something has gone wrong in the process, that can be corrected. But the experience that we have here in Montgomery County is that we are honored to have citizens who take their obligation to serve a jury service so seriously. I have been so incredibly impressed with the caliber, the quality, and the caring of the jurors that come into our courtroom to decide our cases. And here in Montgomery County, I just want to say thank you to all of the citizens that come in and perform jury service, because we understand that it is sometimes a hardship or an inconvenience, but they take that civic obligation very, very seriously. And they do the absolute best that they can to pay rapt attention to the evidence that gets presented to them. And then they receive instructions as to the law from the trial court, and they apply that framework of the law on top of the facts that they have found exist, and they reach what they believe to be a just and fair verdict. So somebody might agree or disagree with the verdict that our jurors reach, but often the people that are disagreeing haven't sat through the trial. They haven't heard all of the evidence.
Out of the jury duty too, aren't they?
Well, and that happens all the time.
Yeah.
And in 30 years I was on the trial bench, it was not unusual to have somebody call down and say, I can't be there. And you work with that. Or they're teachers, so you defer it to the summer. They're going on vacation, so you defer it. They're having surgery, you defer it. But I've never had a situation where a juror afterwards, because we all go back and talk to the jurors afterwards without the lawyers present. Just ask them if they have questions about the system or about the case in particular. This is after the verdict. I've never had a situation where a juror said, you wasted my time. I should have been off on the golf course. This was stupid. This was not, I don't get it. When they're called upon to make the decision, to sign the verdict form with their name, whichever way it is, for the state or for the defendant, a plaintiff or defendant in a civil case, they're making that decision, and they truly understand the importance of that decision. I've never had one that didn't really appreciate the experience.
Okay. Let's take a very short break. It looks like we have about 18 minutes remaining in the show. You're watching You and the Law on DATV. 223-5311. It's an audience participation show. We're trying to wake up you in the audience, so you'll call in. My guess is you're so mesmerized with the commentary of our guest, Judge Jeffrey Froelich of the 2nd District Court of Appeals and Judge Mary Wiseman of the Common Pleas Court, that perhaps you think they'll answer any question that you'd had just by watching, and I think they probably have already done that. But you still have time to call in if you want, 223-5311, and we'll attempt to answer, not attempt to answer, they will answer, I'd attempt to answer, but they'd answer anything that you would want to ask them. And we appreciate you, if you are watching, we appreciate you tuning in and hoping you're learning something, because that's the purpose of the show here, helping out folks that need an inside look at I guess that's what it is, an inside look at the law. So, okay, in the time remaining, I did want to talk about the role of attorneys and the interaction with the courts, and what judges expect, other than obvious ethics and professionalism, but what you're looking for in guiding the cases through, and whether maybe sometimes it doesn't quite work that way.
Well, we're looking for attorneys who are prepared and professional and are fighting hard for the interests of their clients, and respect the court system, and are treating everybody within that system, their client as well as their opponents, again, with respect. And, so Mike, we work in a system where the alternative was to pace off 20 steps and turn and fire, right? So we've made vast improvements in the resolution of disputes in our society. And so we're looking for attorneys who are going to maintain the dignity that the courts surround with our cases and with our justice system. Now, we expect our attorneys to fight really hard for their clients. And again, in Montgomery County, we have an excellent bar. We have an excellent group of attorneys that represent their clients. And of course, we know it goes without saying, we expect integrity and honesty. But what we're looking for are attorneys, and nothing is better, in my experience, than to have a case that has two excellent attorneys that are bringing their best experience, their best knowledge, their best effort to accomplish the interests of their clients in a case. As a judge, that's the moment of joy, where you have attorneys who are really good at their job, who are really hashing it out, and understanding that they do so, again, in an environment that's professional and civil and respectful of their opponents, their clients, and everyone else that's involved in the court system. So, and by the same token, we're asking the clients that come in with their attorneys to be respectful of the court, to be respectful of their opponent and their opponent's attorneys, and to understand that it is a process that places a high value on integrity and good decorum, and bringing the best possible result out of the dispute that they've brought to the court.
And again, I think the media sometimes, because, and I don't just mean the electronic media, the print media, the internet, everything, highlights the cases that are somehow off the wall. The lawyer that, the television shows where lawyers are arguing, they're in somebody's face all the time. They're asking misleading questions and then saying, oh, never mind, I withdraw it. That's good television, I suppose. It's good drama.
Right.
It's not the way it works. Decisions are made on facts. Attorneys know that. And I would reiterate what Judge Wiseman said. We have over 1,500 lawyers in the city, in the Dayton Bar Association. And everybody says, oh, it's too many lawyers, it's just not the case. There's no litigation explosion. People have issues they need help with. That's what a lawyer does. If it ends up in court, then his or her job is to present that case so that the trier of fact, whether it's a jury or the judge, rules in his or her, or its, if it's a company's, favor and makes the right decision based on the facts and the law that they have to follow, not based on theatrics and yelling and emotion and all that. That might happen in some other counties or some other parts of the country. I don't know. It does not happen.
Some theatrics is okay.
Some theatrics.
Within limits and boundaries. So I think it's always important to know that the Judge Judy shows, or the Nancy Grace episodes, or the Jerry Springer-like television shows that try to portray the court system, that's not how it really works. And they take grave liberties with the system, again, to try to juice it up and make it interesting, because an actual court proceeding is a very serious matter. And so it's not going to compete well against Monday Night Football, and it's not going to compete well against Grey's Anatomy. So just as people in their own field, it might be in a medical field, and they watch the Grey's Anatomy or those types of shows, and they're just appalled at what they see portrayed on TV as the things that are transpiring in hospitals or in doctors' offices. And the same thing goes with lawyers and the courts. What people see put on TV for entertainment purposes often bears zero, if any, a resemblance to what an actual court proceeding is. We're pretty plain Jane, plain vanilla, play it by the book types of courts?
Well, I think what's important, and we're not promoting our importance, but a show like this is that we allow the public to see what its courts officers represent in the legal profession. I'm a little appalled at Judge Judy. She is entertaining, there's no question about that, but lawyers don't like to be in courts where judges are constantly haranguing them for their own edification, whether it's Judge Judy or, but those are all like small claims court cases anyway.
Well, those are, but some of the shows you see on Law and Order and those things,
True
judges
enough.
are just, or some of the lawyer shows themselves, even when they don't go into court. How can we get away with this? How can we fool some, that's just,
Well, you have
may
options
happen,
for
but
people
it
that
doesn't.
try to get away.
Except for My Cousin Vinny, which I must say is one of my all-time
documentary.
one of my
That was
all-time
actually-
favorite
that was
law
a real
movies
show.
is My Cousin Vinny, which does make fun of a judge a little bit, because the judge is a bit of a caricature, but
Somewhat pompous.
but a great movie nonetheless.
Well, it stuck to the law for the most part,
In the end.
except for yes, except for perhaps his falsification of his own identity, which may have, if they'd looked into it a little bit more. But I did want to touch on one thing about the Court of Appeals, and
Saving this one for the end.
well,
Okay,
this-
I'm ready.
okay. I mean, the approach by the attorneys in the case is different, of course. There's a more of a personal type of thing in the lower courts, the common pleas courts, the municipal courts, whereas a lot of it, stress is on explaining in writing your position. And I wonder how you felt about the importance of the presented written argument as combined with the oral argument.
First on the word lower courts. I, having been a lower court judge
Right.
for so long,
I didn't say undercourt.
There's trial courts and there's appellate courts.
Right.
We like to say in the Court of Appeals that you should make your argument so simple that even an appellate judge can understand it. Okay.
Okay.
You laser it in, whereas you're right, in a trial court, there's a lot of different things going on. But by the time you get to the Court of Appeals, you've had assignments of error. You said, this is what the error was. This piece of evidence should not have come in. This witness should not have testified. There's a lot of writing having to do with it. It's a lot different than being in a trial court where things are flying around all the time. And we spend a lot of our time going over the briefs, the counter briefs, the rebuttal briefs, and then only maybe about a third of our cases actually end up in oral arguments. It's rare, but not totally unheard of, and an oral argument's going to change our minds totally. Because good lawyers are going to be able to make good arguments in the briefs. And then we can get focused on it. We can do our extra research if we need to. And the oral argument kind of is for those cases that are right on the edge. But again, it's going to sway us because of the law, not because, oh, this person really believes passionately in his or her cause.
Well, there's some feeling amongst attorneys, I would say generally, some feel as though I've said it all in the brief. They don't want to hear me just reiterating that. And there's others that say, here's your last chance to either explain this, or if one or two of the judges have a particular question, your last chance to answer.
And I would say the second is the better choice. If it's truly something that, here's the case from the United States Supreme Court that says X, and we're going to follow that. That's our oath. Doesn't make any difference what anybody argues or what anybody else says. That's our oath. We're going to follow the law. But on the other hand, even if you get up there in front of us and say, I've argued so-and-so, the other side argues so-and-so, as I said in my brief, these are the reasons you should affirm the trial court below or reverse it. Do you have any questions?
Mm-hmm.
Even if you say that, there may be somebody on the panel, there's always three of us on the panel at any given time, says, yeah, you're right on assignments 1 through 5, but number 6, I didn't understand how that squares up with the Smith case or whatever from the Ohio Supreme Court. How do we rule the way you want us to in that? And then you have that give and take, that discussion of the law and the facts that may not have been spotted if you're just doing it in the written brief.
So it might be worth a little extra effort to come on down to the court for that. What is it, half an hour y'all give us?
15 minutes per side.
15
Yes.
per side, right. And I think the clients appreciate that extra effort, even if it's, as you said, do you have any questions? And then being able to field those questions.
But again, it would be important for the lawyer to tell the client what a court of appeals is all about. And not that I'm going to be able to call witnesses, or you're going to be able to say, one person said this, one person said that, the jury shouldn't have believed this person. Well, the jury did believe that person, and we're not going to say they were wrong in deciding that.
Well, I agree with you on that, because just about every case that, I don't lose every case, but occasionally, well, I don't lose them, the facts lose them, as you said earlier. But that is a general question. Do we get to ask them different questions next time, or could we bring in such and so? And it's almost deflating to explain to a client's family and clients that it's what somebody may have done wrong. And having done this a number of years, I think that judges aren't trying to get anything wrong. As Judge Wiseman said, they're trying to achieve a just result. But sometimes people's impressions are different, and that, I suppose, could make the difference. But that's what you're looking for. I think, and tell me if I'm wrong, and I don't think I am, that most cases where you say the jury got it wrong aren't going to get reversed.
That's correct.
And why is that?
Because that's the role of the jury, as we were talking about before, to
Right.
make those factual
They saw
decisions.
the facts.
In
Okay.
fact, if we disagree with a jury decision, the Ohio Constitution requires that before we could reverse that, just the decision, not an error of law, it has to be a unanimous panel. Whereas every other decision can be a 2-to-1 decision, or a 1-1-1 with concurring opinions. But it has to be a unanimous verdict, because of unanimous decision of the panel, because our system gives such weight to that jury process.
Excellent. Okay, we have 3 minutes left. One, and I won't put anybody on the spot here or anything. In fact, our floor director did just concur with my 3-minute finding here.
I won't reverse it.
Thank you, Judge. There's commentary that the courts are overcrowded, there isn't enough justice, it's not going fast enough. What role do the judges have in more efficiency, but the same amount of justice and temperament and whatever?
Well, we all know that justice delayed can be justice denied. We've heard that saying. But by the same token, rushed justice can also be justice denied. And so we're always trying to find that appropriate equilibrium between time and efficiency and justice. And at our court, we use a lot of technology to try to make us as efficient as we can possibly be. We rely extensively on the attorneys to tell us how much time is needed for a particular case. And so, again, we try to, there are some cases that require a great deal of time. So the case might get filed and it might not go to trial for 2 years. And then we have other cases where the case gets filed and we're ready to resolve that case in 4 months or 5 months or 6 months. And so again, we try to gauge and work within the time parameters for a case that's specific and unique and appropriate for that particular case and the issues that it presents.
And the Montgomery County Trial Court has a reputation of being called the rocket docket, because both at the trial level and at the appellate level, the judges take a responsibility in addition to the lawyers of moving the cases along. It's much more common to have lawyers say, Judge, I don't think I can stick to that schedule. I don't think we can do oral arguments then. I don't think I can file the motion for summary judgment in that time. And the judges are pushing along because we know we have an obligation to the system of justice, but also to the parties that are in that case.
Okay. It's been great having you both here. We've got a little bit of time left, just enough for me to close up the show. You've been watching You and the Law, a monthly program designed to bring Montgomery County citizens news of the legal world around them and even some other counties who may be getting this program. I want to thank all the volunteers who've made this program possible and thank our special guest, Judge Jeffrey Froelich of the District Court of Appeals, 2nd District, and Judge Mary Wiseman.